got with me my partner Amanda Walker and Dan Deacon here in Washington, and we are going to be talking about addressing employee complaints, whistleblower claims, and OSHA notices of hazards. This is part of an ongoing webinar series from the labor and employment and OSHA practices here at Conn Maciel. So a little bit about me, and then I'll let my colleagues introduce themselves too. I am the chair of the Labor and Employment Practice Group here in Washington, D.C. I handle all sorts of matters for employers across all industries in the employment relationship. I'm a litigator as well. I litigate and defend companies on the wide range of employee complaints in Title VII, EEOC charges, discrimination claims, things of that nature, and we'll be talking about that today. I also counsel employers on how to best protect themselves from facing employment issues in the workplace, compliance issues under federal and state law, and where appropriate, also advise union and non-unionized workplaces under the National Labor Relations Act. Okay. Amanda, go ahead.
Yes, good afternoon. Excited to be here on the telephone with all of you. My name is Amanda Walker, and I'm a partner in the Workplace Safety and Health Group. I've been practicing occupational safety and health law for over 10 years. I got my start in the practice area by working for the agency at the national office in Washington, D.C., and also did a tour of duty in the solicitor's office where I also focused on occupational safety and health issues before transferring over to private practice and representing employers and trade associations in a wide variety of different occupational safety and health issues, whether it's compliance related or helping getting in interpretation or if it's during the inspection. My practice includes all of those areas and the full range of litigation that goes along with enforcement actions and contesting them. Also, too, get involved in some CSB and EPA issues as well, and have been involved, unfortunately, in a few DOJ matters. That's generally when an OSHA inspection or investigation results in a criminal prosecution. And now turning it over to Dan.
Hi, good afternoon, everyone. My name is Dan Deacon, and I'm an associate here at Conn Maciel Carey in the Washington, D.C. office, and I work in both the OSHA Workplace Safety Practice Group and the Labor and Employment Group. I represent employers during inspections and investigations conducted by federal and state OSHA. I also advise and counsel employers in responding to notices of employee safety complaints, OSHA citations, and notices of alleged hazards. And on the labor and employment side, I represent and advise employers in all aspects of the employer-employee relationship, including wage and hour disputes and claims of discrimination. And finally, I also help out reviewing and revising employee handbooks and workplace policies and procedures.
Okay, so with that, we're going to talk about what we're going to cover today. This is, a focus on employee complaints and how you can address them through whistleblower protections, both on the labor and employment side and on OSHA. So we're going to start out talking a little bit about major anti-retaliation and whistleblower protections. We're going to review the Title VII charges, EEOC charges, as well as charges that are filed with OSHA, and the burdens of proof and enforcement actions and how you can defend against those enforcement actions. We'll talk about how to respond to whistleblower and retaliation complaints, and then finally close with some tips on ultimately how to avoid them so you're not faced with this situation to begin with. I'm going to cover the major anti-retaliation and whistleblower protections under Title VII. And the EEOC is the primary agency that enforces those laws with respect to anti-discrimination and anti-retaliation. You've got Title VII of the Civil Rights Act, which covers discrimination based on race, based on religion, based on gender, disability, etc. You've got the Equal Pay Act. You have the Americans with Disabilities Act that covers individuals with disabilities. You've got the Age Discrimination and Employment Act, and that covers anyone who is 40 years or older. And under the federal law, and EEOC enforces that. And then most recently, the most recent law that's come into effect a few years ago was the Genetic Information Non-Discrimination Act. What happens is the EEOC will look at those in addition to not only the underlying charge of discrimination, but there's also a retaliation angle to each of those, and that's what we're going to cover today. So Title VII's anti-retaliation provision is pretty specific, and essentially there's two types of it. So most of the retaliation claims that the EEOC faces and that we see in the employment context are brought pursuant to Title VII. And so if you think about it, it's discriminating or retaliating or taking adverse action against an employee who has either themselves filed a charge of discrimination or has assisted others in participating in the enforcement proceeding. And so the key is you can't discriminate or not hire someone or terminate or otherwise take action because that individual either opposed a practice that was unlawful under Title VII or, again, has participated in an enforcement proceeding. We call these two prongs either the opposition clause or the participation clause. And most of the retaliation claims come under the opposition clause. It's when someone has brought a complaint to HR, raised an issue of discrimination, that underlying charge is investigated and resolved, and then 2 weeks later or 3 weeks later, that employee gets a legitimate performance problem and criticism and written warning, and that individual thinks, well, it's not because of poor performance, it's more closely related to my previous complaint to HR. That's the type of opposition activity that Title VII is looking to enforce.
Okay, talking about OSHA whistleblower role. OSHA administers over 20 different whistleblower statutes that are quite varied. They can deal with food safety to airline safety to provisions under Sarbanes-Oxley. And it's interesting, when OSHA, a lot of these provisions don't have to do with safety and health. OSHA, the OSHA Act, which was implemented in the early 70s, was one of the earliest whistleblower provisions, and OSHA started having an investigation task force to investigate these whistleblower provisions. And as more legislation was passed, including whistleblower provisions, Congress delegated this authority to OSHA. So that's how they got to have roughly 22 different statutes that they administer whistleblower, or they have authority to administer whistleblower investigations under. This has been somewhat challenging for OSHA throughout the years. A lot of times they get a new statute without funding, but they still have authority for it. Moving on to the next slide. In particular, OSHA continues, even though they administer 22 different statutes, they continue to receive the most whistleblower complaints under Section 11C of the OSHA Act. A Section 11C complaint is when an employee is alleging that they have been discharged or discriminated against for exercising their rights under the Occupational Safety and Health Act. And what that typically can include is if they filed a complaint to either OSHA or submitted it to their supervisor and are now experiencing some discrimination, maybe a reduction in overtime hours, or maybe they missed out on a bonus. It can also be for protected activity, also includes participating in inspections, providing testimony to OSHA during inspections, participating if the matter goes to trial as a witness. So those are all protected activities. And OSHA's whistleblower statute, we have the language here. It's often referred to as Section 11C of the OSHA Act.
Dan here, and I'm just going to go over some of the statistics over the past few years to highlight how retaliation claims under both Title VII and Section 11C of the OSHA Act have seen a steady incline, and you've seen a steady incline in the number of retaliation claims brought under both of those statutes. So with respect to Title VII retaliation claims, consistently since 1997, as you can see here on the chart, they've made up a significant portion of the claims brought against employers. However, for the last about 7 years in specific, retaliation claims have been the most of any one type of claim filed with the EEOC. That's increasing to over 45% of the charges filed with the EEOC in fiscal year 2016. So if you look back dating 20 years ago, that number was only 22.6%. 22.6% of claims under Title VII included a claim for retaliation. So if you think about that now, we're up to nearly 1/2 of all Title VII claims brought to the EEOC are going to include a claim for retaliation. You also see here that the two other most popular claims have stayed largely stagnant over the past few years, that being race and sex discrimination. So what this means is you're seeing more retaliation claims being brought in addition to those types of claims. So what you'll see often now is a race discrimination claim being brought, but a retaliation claim is naturally going to be tagged onto that. So moving on to some of the statistics under Section 11C, prior to 2015, the number of cases here had remained pretty stagnant, around 1,700 cases filed per year. And that was since the online filing system went into effect. That was in late 2014, I believe. There was a substantial increase. We're looking at about a 10% increase in the number of retaliation claims brought under Section 11C. And on the OSHA front specifically, claims under 11C have increased by nearly 42% over the past decade. As many of you are probably aware, during that time the Obama administration has taken several measures to combat retaliation in the workplace, and that culminated in 2016 with a new whistleblower investigation manual, and also, although not specifically a Section 11C claim, the anti-retaliation provisions that were snuck into OSHA's e-record-keeping rule. And as Amanda previously mentioned there, OSHA inspects whistleblower retaliation claims for about 22 different statutes, but you'll notice that the whistleblower cases under 11C make up the majority of whistleblower claims. It's about 62% of all whistleblower cases in 2016 alone. So this slide here, I mean, the previous two slides kind of scary numbers. You see the steady incline in the number of retaliation claims and cases brought before both the EEOC and OSHA, but this kind of gives a little, I guess, some reprieve for employers. As of 2016, it was less than 2% actually of these claims received a merit determination from OSHA, with another 27% settling prior to OSHA having completed its determination process. Additionally, a total of 74% of the 11C whistleblower claims are actually withdrawn or dismissed. So you're really only seeing a very, very, very small number of those claims succeeding on a merit determination.
Okay, so next we're going to talk about agency guidance on burdens of proof and enforcement when they receive a claim, and understanding the process for how complaints get filed and what happens next at the agency level. So for an employee making a complaint to the EEOC, again, that's the federal administrative body that has to receive the complaint in order to proceed with any type of civil lawsuit thereafter. There's also state administrative agencies, California, Washington. Most states have a state equivalent. We're just talking today about the EEOC, but oftentimes the process is similar. So anyone, an employee, an applicant, or former employee, can file a complaint either in person by going to the EEOC field office where they're located. There's also a new online pilot program that the EEOC is testing out, so you can file things online. You can complete the required form by mail. You could even start the process over the phone. There is, however, a certain document that has to be signed by the employee under penalty of perjury before the charge officially gets logged into the system. And that's important because you want to make sure that you're looking at that date when you receive a charge of discrimination to make sure that it was timely filed. Generally, you need to file, an employee has to file a complaint within 180 days, could be 300 days, again, if there's a state basis. So that's important to look at. Once the EEOC receives the charge, they're going to notify the employer and let you know what you need to do next. sometimes there might be a box on the form that says no action needed at this time. That means that the EEOC is looking at something. It could be a jurisdiction issue. It could be a timing issue. It could just be they need more information from the charging party before they can really perfect and finalize the charge. Other times they'll contact you and let you know that they want to get a position statement from you. And we'll talk a little bit more about what that means. But essentially it's a letter or a document that's provided to the EEOC that explains sort of the facts about the employee's circumstances and from your perspective, what the legitimate business reason was for whatever adverse action was taken. The investigator will then review that evidence and then sometimes conduct interviews with the parties, interview coworkers, either by telephone or sometimes we'll have a fact-finding conference when they come in to their office. So it really runs the gamut. The EEOC also has a mediation program that in the current administration, they're really shifting their priorities towards this voluntary mediation program. And it can be very effective because the EEOC, as Dan showed you through those statistics, receives over 90,000 charges a year. And they can't process all of those quickly. And so they try and prioritize, but if you're able to and willing to go to mediation, you will not then have to spend time and money focusing on a position statement. Instead, you can just go to mediation and see if that resolves the situation. And if it doesn't, mediation then closes, and then you can proceed to filing a position statement after that. So that's just something to consider with respect to the mediation program and the current emphasis. Someone just asked if you can have outside counsel during mediation. Absolutely. It's not required. But sometimes it's helpful to have a lawyer who knows the situation, who can serve as a little bit of an intermediary. Oftentimes, EEOC mediation, you've got the employee and you've got maybe the HR representative from the company or a manager from the company who knows the situation. That can be very effective because you've got the individuals talking to each other. But I also do think it's helpful to have an outside lawyer there who knows the settlement process, who's able to prepare documents if the case is able to be resolved so that everything is done, because the mediator is there as an advocate for neither party and can't really help facilitate the proper documentation that would be needed to fully settle and resolve a charge in the best interest of a company. So that's something to think through, although not required to have outside counsel. As I said, a charge does generally have to be filed within 180 days from the day the alleged retaliatory act took place, or 300 days, again, if there's this state and local law. So that's the first thing you should be doing when you're looking at the charge is find out whether it's even timely. Believe it or not, I've seen a lot of charges that come across my desk from clients where I'm looking at it and more than 300 days have passed. And so that's something that you would want to raise if this is a Title VII charge. There's no really specific timing for how a charge can be investigated and concluded. And again, there is a huge backlog of cases. I mean, the administration is eager to clear that backlog, but that still means that these investigators are working very hard. I have several cases where I've gotten a charge dismissed or resolved, within a few months after filing the position statement. And in other cases, I have, charges that are pending for over a year. So it really runs the gamut. It just depends on where you're located and how busy the EEOC agency where you're located is. After 180 days, if the EEOC has not completed its investigation, the employee has the right to withdraw the charge from the EEOC and seek a right to sue letter and then file suit in court. Otherwise, you have to wait until the EEOC is finished. Then they'll issue a determination letter. And in that determination letter, if they find no probable cause of discrimination, they will notify the employee that they have 90 days to file suit in court before their claim expires. That's a statute of limitations. It's a strict deadline. If the employee waits more than 90 days and then files suit, the company would have grounds to get that case dismissed because it's not timely.
Going on to how to file a 11C or an occupational safety and health complaint or whistleblower claim under the OSHA Act. It's actually pretty easy. OSHA makes employers, private employers, post signs in their workplace that has a variety of different information. One piece of information that's on that poster is an 800 number to make such complaints, and also gives further direction on how to do that. But basically, OSHA makes it as easy as possible for the individual to make a whistleblower claim. They can either go to the OSHA office, the area office, make the complaint in person. They can send it in by fax. There is a portal on OSHA's website that you can submit it there electronically, or you can send it via U.S. mail. No matter how you send it, the date that it is actually submitted, whether it's an email, the day that you hit send, whether it's the day that you go to the actual office, that is the day that it is considered to be filed, which is a very important date, and we'll talk about the time frame that you have to file them on the next slide. But that is a key date to keep in mind and look at when you're receiving and reviewing such a complaint, an 11C complaint. Upon receipt of the complaint, OSHA will assign it to a whistleblower investigator. Whistleblower investigators are separate and apart from the general OSHA enforcement inspectors. There's a special division within the within OSHA that has whistleblower investigators. So it's not as though the person that's out there checking to make sure that your guards and your lockout-tagout procedure is compliant will be also evaluating your whistleblower claim. Two completely separate groups of investigators. An investigator will be signed, and they are spread around the country based on OSHA regions and area offices, so it's likely that you'll get someone who's somewhat close to the office, and they will first, on the face of the complaint, determine if it's timely filed, determine if an individual has actually signed the complaint, and, is there a discriminatory action alleged in connection with a safety and health protected activity. Moving on to talk about those deadlines that are very key. OSHA actually has a pretty short deadline. If a discriminatory action is taken, an employee only has 30 days to file a complaint with OSHA. If it is after the 30-day period, it is not a valid whistleblower complaint. It's very hard to overcome that 30-day period. You have to show duress and some other things, but it's a pretty hard standard to meet, so 30 days is pretty firm. Then you start counting that day, the first day that the employee would have received communication or knowledge about the alleged discriminatory activity. Under the 22 different whistleblower statutes that OSHA administers, there's different filing deadlines. 30 days is one of the shortest, and then as you go through and you see the SAW, which happens to deal with, I believe, airlines or SOX, you have 180 days to file that complaint. And so it depends what authority or whistleblower claim you are submitting. But those dates are very important. Once OSHA receives the whistleblower complaint and they see that it has, it's been filed in a timely manner, it has a signed signature on it, it makes an allegation of discriminatory action related to a protected safety and health activity, the investigator is going to start to do some background investigations. They're going to talk possibly to the complainant who's filed it. They're going to reach out to the employer to see if they want to submit a position statement. During these sorts of investigations, a lot of times the lawyers are involved. It's not required, but as Kara mentioned before, knowing the process, there's a tremendous value in that, and what kind of information to provide to OSHA in response to these whistleblower claims. If there's evidence for the discrimination, or not evidence of the discrimination, but justification for an adverse action, presenting that in the employee response. At the end of the period for the investigator to review, they have 90 days. They'll make a determination if they think there is a valid whistleblower claim. They'll notify the parties, and at that time, the parties have an opportunity to appeal it to the national office. And then there's an appeals process that's set up internally within the Department of Labor to review the investigator's decision. There is no private cause of action under 11C, so the individual who files a complaint can't decide they want to leave the investigation process at OSHA and go file in federal court. They have to stay within the administrative process, and OSHA only has the jurisdiction to file on behalf of the employee if they decide to bring it to district court, if it's not resolved through the internal appeals process.
So in evaluating 11C whistleblower complaints, there's now actually, as of about almost a year ago, a new standard that the agency is going to be using in reviewing these complaints. So that was back in January 2016, OSHA published their new Whistleblowers Investigation Manual, which provides guidance for inspectors to evaluate these whistleblower claims. Prior to 2016 and this new investigations manual, a complainant actually only had to establish a prima facie case of retaliation by a preponderance of the evidence standard. And this new enforcement manual, this guidance, eliminates that standard for determining whether a merit finding should be made at the agency level. And that, therefore, is going to reduce the possibility that a complaint is going to be dismissed. So basically what we have here is it's a lower burden, and it's more of a fluid standard that's a little more discretionary. Now all an employee really needs to establish is reasonable cause that a complaint has merit. And they're going to assess that by looking at evidence provided by both sides or otherwise gathered during the investigation and determine whether a reasonable judge could find a violation, not whether one did actually occur. So that initial evaluation of the complaint at the agency level is going to be much less than what you're going to than the burden of proof at the hearing stage. So moving on here to the elements of retaliation claims and 11C whistleblower claims, they're the same, right? So you might be asking yourself, I just went over this new standard, the standard of review at the agency level. Why do they have to establish this prima facie case? Well, the investigation manual still says that the claimant actually has to prove the three elements of a retaliation claim. And they're the same three that a claimant under a Title VII claim has to prove as well. And that's that the employee engaged in protected activity, 2, that the employee suffered an adverse action, and 3, a causal connection between that protected activity and the adverse action. So the Section 11C intake analysis is no longer, as I said, that the claimant has to establish the case by a preponderance of evidence, but now it's that reasonable cause standard. And the manual specifically states that OSHA need only believe that a reasonable judge could rule in favor of the complainant. So moving on to that first element, I'm just going to run through the prima facie elements one by one here and give you an overview of those. And first we're going to address what is protected activity. Well, protected activity is more of a legal term, and it basically describes activities that workers can engage in without fear of retaliation. On the slide here, you're going to see some examples of what is protected activity under both Title VII and Section 11C. So as you can see on the left, some of those examples of protected activity under Title VII are filing a discrimination charge, complaining to an employer about workplace discrimination, or participating in employment discrimination investigations, or a lawsuit itself. On the OSHA side, the guidance, the investigation manual actually lists protected activities, and those include making a workplace safety complaint to OSHA, participating in an inspection, complaining to the employers about workplace safety concerns or issues, also reporting an injury, requesting information to apply for tax credit, and finally, reporting or refusing to participate in acts reasonably believed to be in violation of the Affordable Care Act. So number 2, what is adverse action, the second element of a prima facie case? Well, an employee must show that the action might have dissuaded a reasonable worker from making or supporting a charge of discrimination. So there's two elements to this assessment, and that's materially adverse, which basically means that the harm is significant, although not necessarily tangible, and it's to a reasonable employee or applicant. Materially adverse to a reasonable employee or applicant, and that's analyzed under an objective standard. So OSHA's new Whistleblower Investigations Manual recognizes that an employer may have taken certain actions against a complainant that don't necessarily qualify as materially adverse as you would normally conceptualize that, and that they don't cause the complaint to suffer any material harm or injury. Therefore, to qualify as an adverse action, the evidence really must show that a reasonable employee would have found the challenge action materially adverse. And in analyzing that, the investigator can actually interview coworkers to determine whether that action would have dissuaded other employees from engaging in protected activity. So the investigation will be pretty widespread. Similarly, under Title VII, an adverse action does not have to have a tangible effect on an individual's employment. It really needs to only deter the individual from engaging in protected activity or have the potential to do so. So a couple examples of adverse actions under both Title VII and Section 11C of the OSHA Act are listed here on this slide. The first column on the left here is the typical Title VII adverse actions, including discharge, demotion, failure to hire, failure to promote, denial of pay. And on the right, you have the OSHA adverse actions that are typical, including blacklisting, harassment, hostile work environment, making a threat or intimidating workers, denial of overtime, layoffs or suspensions, and reducing hours. Additionally, there's some case law that has stated actions that impinge on a former employee's future employment and future employment prospects would also be considered adverse. One such example is negative job references, actually, so be careful for that. So now we're on to the third and final element of the prima facie case, causal connection. So what is causal connection? Well, under both Title VII and Section 11C, the employee needs to show that but for the protected activity, the adverse action would not have occurred. This but-for standard, unfortunately, both the EEOC and OSHA have significantly decreased a claimant's burden under this element. We talked about the OSHA Whistleblower Investigation Manual decreasing that initial burden at the intake stage, where it's now just a reasonable cause standard. Additionally, the EEOC in 2016, back in August 2016, revised its retaliation guidance, which is titled Enforcement Guidance on Retaliation and Related Issues, and that also decreased an employer's burden of proof to demonstrate that an employer acted with retaliatory intent. So under this causation element, the but-for causation analysis doesn't require that the retaliation be the sole cause of the action. Instead, there can be multiple but-for causes, and retaliation needs only to be one of them, one of the causes of the materially adverse action. The guidance also adopts this kind of new way of proving causation, what the EEOC refers to as this convincing mosaic, which they explained as a combination of different pieces of evidence to satisfy the causation standard. In other words, the employee can make a case if they can cite the individual pieces of evidence which, in combination, infer retaliatory intent. So I'm going to address employer knowledge here, and this comes up as a defense, a pretty big defense for employers, and should all keep this in mind. It's often an important inquiry in retaliation cases. Employers can demonstrate that the person involved in the decision-making, that decision to take adverse action against an employee. They can demonstrate that they were unaware of that protected activity. And in that case, an employee is not going to be able to establish that the protected activity was the basis of the adverse action. So the OSHA Whistleblower Investigation Manual actually describes a couple examples of what would be considered inferred knowledge, and this is something that you kind of have to take with a grain of salt. So for instance, if the complaint is made about a piece of machinery and there's only one operator at that facility, OSHA is going to infer that the employer has knowledge of who made that complaint. For example, another example, if there's a small company or a facility where everyone knows everyone and what they're doing, just a small company with a few employees, OSHA can also infer in those situations employer knowledge. So it may be difficult to establish in some cases, but it is important to keep in mind when evaluating these claims that they come across your desk. A lot of courts and the EEOC actually use what's called the cat's paw theory, and that's inferring knowledge to an employer through a supervisor's actions. I just want to note that although the EEOC uses this inquiry, it hasn't been adopted universally by all of the courts throughout the country. There's several Circuit Court of Appeals that have not ruled on this issue, and the cat's paw theory, where you can infer knowledge to an employer through a supervisor's actions, has not been adopted. So also there's just a few minor differences in the analysis of employer knowledge between the EEOC and OSHA. OSHA considers employer knowledge as its own separate assessment of the complaint. In other words, the investigation needs to show that a person involved in the decision to take the adverse action was aware or suspected that the complainant engaged in protected activity. On the other hand, the EEOC will consider employer knowledge in determining whether there's a causal connection between protected activity and adverse employment actions. Finally, the last slide here on causal connection, I want to talk about temporal proximity and the importance in the analysis. So another element that can influence an agency's analysis of causation is this concept of temporal proximity, and that's basically the time in between when an employee engaged in protected activity and when the adverse action was taken. So that's one way an employee can establish that causal connection, is just simply by showing that the employer took the action, the adverse action, shortly after the employee engaged in the temporal proximity. However, case law has expanded on this, and the time frame is going to need to be pretty close. The Supreme Court has actually held that 3 to 4 month period between protected activity and adverse action is insufficient to establish a causal link. So if someone's facing a retaliation claim and their proof of causation is temporal proximity and it's falling well outside this 3 to 4 month period, you're going to have a solid defense. Finally, if and when an employee establishes the prima facie case of a retaliation claim, the employer has the ability to negate that case by providing a legitimate non-discriminatory reason for the adverse action. So here's the employer is going to need simply to satisfy a burden of production, providing a reason, this legitimate non-discriminatory reason. It's not a burden of persuasion. The burden of proof and the burden of persuasion is always going to remain with the employee, the complainant. And this is known what's been commonly referred to as the McDonnell-Douglas burden-shifting framework. So if the employer satisfies that burden of production by providing a legitimate non-discriminatory reason for the adverse action, the employee ultimately has to carry that burden of persuasion to demonstrate that the employer's reason is pretext. In other words, it's a farce, and that the real reason for the adverse action is retaliation.
Focusing back on OSHA, just one quick thing. I noticed that somebody had asked a question, what kind of judge hears a case, and I think that was in relation to 11C claims, occupational safety and health whistleblower claims, and it is actually not an ALJ. It goes through OSHA, the investigators. There's an appeals process. It's internal within OSHA where there's I believe it's an appeals committee that reviews it. And at the end of that, if they still continue to believe that the employer has a basis for a complaint, it would be filed before a federal district court judge. So just wanted to clarify that before turning back to this slide. Now we're talking about a slightly different type of complaint for OSHA. This one is an allegation of a safety and health concern in the workplace. This does not have the discriminatory element. Basically, an employee could call up OSHA or submit a notification on their website indicating that there is some element in the workplace that they consider to be a safety and health concern. And these concerns can be very varied. I've seen quite a few. One of them it had to do with the quality of the water coming out of the faucet. Another one had to do with concerns with regards to the Wi-Fi and what sort of potential ways they were being impacted by, but they can really run the gamut with regards to what these allegations are. And so any employee or any employee representative, and I've also seen where a spouse has filed one on behalf of an employee, can submit these safety and health concerns, and OSHA takes them. This is a form, there's a form for it, but OSHA has also developed a system to take these complaints over the telephone where an operator will ask questions, as well as an online portal for you to submit the information. These complaints will typically be routed to the area office with jurisdiction over the work site. If it happens to be a complaint that's made on the federal system, OSHA's federal system, and it actually has to do with a workplace at a state plan state, they generally do communicate that to the state plan state, and the state plan state follows up on it, and it also works the other way. If the complaint's made about a federal jurisdiction to a state plan state, they'll share that information with federal OSHA. That transfer does take a couple days delayed, but eventually there will be contact from the jurisdiction or the party having jurisdiction over the matter. Once they do receive these complaints, they take a look at it to see if it merits an on-site inspection. This is criteria that they look at to make that determination. They're looking for a written signed complaint by a current employee or employee representative. They're looking for an allegation of a safety and health violation that is likely exists. Some of these complaints can be very short on details, so the more detailed it is, more specifics, the more likely the danger is to exist. That's going to tip OSHA on the scale to go out and conduct an on-site inspection. Also, too, if there's an imminent danger that seems that it's an immediate harm, something a very serious category for safety and health, they're going to send somebody out there. Also, a consideration is whether or not an employer is part of a local or national emphasis program, because many of the local and national emphasis programs can be expanded, or basically an employee complaint gives OSHA the jurisdiction to come in and conduct an inspection, and then they can expand the inspection not only from the allegations on the complaint, but to a wall-to-wall through the local emphasis program. And that's also an important point. When a OSHA investigator, if they do decide to do an on-site investigation and they show up and say that it is based on an employee complaint, the employer does have the right to see the complaint. Usually the individual who made the report, their name will be redacted, but you can at least understand what the allegations are, and the inspection should be focused narrowly to those points, unless, of course, there's a basis to expand the inspection. These are just some other factors that they'll look at. I've also seen there might be already an inspection going on at a facility, and a complaint gets filed simultaneously. That complaint could also spur a separate inspection, or sometimes they might roll it into the ongoing inspection. But that's kind of the criteria. that they look at to determine whether or not they're going to conduct an on-site inspection or do the phone and fax inspection. If they decide not to do an on-site inspection, you will first learn about this employee complaint by receiving a telephone call from an OSHA representative saying that a complaint has been filed. They'll give you brief details with what the complaint is, what the safety and health concerns were, and then they follow up with a form indicating it in writing, and they ask for the employer to investigate the allegations and report back to them on their findings and any corrective actions that they've taken. This is a pretty common thing. Deal with these probably at least once a week for employers. Tips in responding to these, more proactivity, conducting an inspection, even if the safety and health concern seems to be kind of out there with regards to Wi-Fi and, kind of pointing to some source that this is a safe activity, that you've looked at it and you confirmed that it is safe, and responding to OSHA in a similar fashion, just showing that you've been proactive, you've taken this seriously, you've done some sort of investigation and done proactive measures. Goes a long way in helping close these fax phone investigations out. You might not receive a letter indicating that it's been closed. Some area offices do provide letters, and other ones you just don't hear back from, and there's never an on-site inspection. On occasion, you can go through a phone and fax investigation procedure with regards to an employee complaint and respond to it, don't hear anything back, and after a period of time, OSHA has decided that the response was inadequate, and they do show up and do a on-site inspection. Pretty rare, but it does happen. Usually the employee complaint is closed out by the phone and fax procedure.
Okay, and with that, we'll talk about sort of the final two sections of the materials on how to respond to whistleblower and retaliation complaints and how to avoid them in their entirety. So the first thing is, if you do get a whistleblower complaint and the complaining employee is still employed, you want to take steps to make sure that that individual is not going to be retaliated against any further, talking to managers, supervisors, coworkers, whatever the situation is, just so that managers are aware that a charge has been filed. And importantly, you'll want to conduct your own investigation into the complaint, looking at whether it's timely, collecting documents related to the complaint, looking at personnel files, for example, or your handbook policies and procedures that relate to the charge. Any other prior complaints that the individual may have made in the past, or any disciplinary actions or internal complaints that have been made. You want to interview employees with any knowledge of in the complaint, including decision makers, other supervisors, or other non-management personnel that may be associated, including HR. And then record your investigation and findings. All of that is good because it's useful and ultimately will be used to prepare the position statement and response letter in order to respond to a charge of retaliation. I saw a question come in that what happens if during your investigation or the EEOC's investigation it's determined that the employee did not make the complaint in good faith and was just using it to create a headache for the employer. If you determine through an investigation, either an internal investigation before it gets to the EEOC or at the EEOC stage, that someone is pursuing an investigation in bad faith, certainly that's going to weigh heavily in the EEOC's mind on credibility and will likely lead to a dismissal of the charge. And then hopefully you have an updated handbook policy and complaint procedure, harassment complaint procedure in your handbook. And in that you can put language in there that says if an investigation reveals that a complaint was made in bad faith, you have the right to discipline the employee for that. So take a look at your complaint procedure, and if you don't have language like that, consider updating it in the next time you update your handbook. Okay, so the position statement that it gets filed with the EEOC and OSHA, the primary goal is to give the investigator context about who you are, what your business is, really frames the story in a way that's easy for the investigator to follow. It's going to explain why you took the actions that you took, and it's going to highlight those facts against applicable legal case law and the law. So it's really so far they've only heard from the charging party, and so this is an opportunity for you to tell your story. You want to provide documents that are easy to review and that will ultimately refute the charging party's facts and their charge. You want to demonstrate that you're taking these situations seriously, that you have an anti-harassment, anti-retaliation provision in your handbook, and that you take steps to investigate complaints, and that you don't engage in retaliatory actions. This establishes trust with the agency and gives you credibility with the investigator. Ultimately, your job is to persuade the agency to issue what we call a no cause finding. And it also gives you an opportunity to persuade a prospective attorney, or if the individual is represented by a lawyer, that case is weak and should not proceed to litigation if a no cause finding is determined. So you've got two sections of your position statement. You have your statement of the facts, and as I said, you want to provide background on the parties, including your type of business, where you're located, what the relevant issues are in your workplace. You want to cite as exhibits and quote the relevant policies and procedures. You want to talk about the charging party, their job duties, what they do for your company. And then you want to describe the context for the basis of the charge. You want to introduce the key players, the decision makers, give them an org chart, understand how things happen, who makes the decision, discuss issues if it's a performance issue, if the adverse employment action relates to a written warning or a discipline or a termination. You want to explain why that disciplinary action took place, why there might be some progressive discipline or a history of poor performance. And ultimately, you want to explain the reason for what the actions that you took. It was legitimate, it was for reasonable business expectations, and that the action was lawful. Then you go and you turn to the legal analysis of the position statement, and this is often where outside counsel or in-house counsel can be very helpful, particularly because you're able to find case law that's based on the circumstances in the facts section of the position statement, and be able to tie the law to the facts can help show and convince the EEOC that the claim is legally unsupported and most likely fail, again, if proceeding. And that also is helpful to show opposing counsel. So you're going to lay out how the charging party has failed to meet each of their legal burdens under each of the elements that Dan talked about earlier. For example, you want to establish the legitimate reason for the adverse action, and the employee can't show pretext. Or they can't establish the causal connection between protected activity and the adverse action because 3 or 4 or 6 months have passed and there isn't temporal proximity. Or just that the activity itself was not protected by the applicable law. They didn't engage in the right type of protected conduct. You want to add supporting documentation, as I said, copies of policies and procedures, any disciplinary notices, affidavits possibly of witnesses, but you want to be very careful about the type of information that you provide, because whatever you produce to the EEOC, that will be disclosed to the employee and ultimately then could be used later on down the road if it does result in a case or litigation. So you want to make sure that everything is accurate, everything is appropriate, that there's no confidential information in the attachments, because whatever you produce ultimately will be used in discovery later on in a lawsuit. And this is sort of what I just mentioned. So the EEOC has updated its response to the opposing party in disclosing the position statement. The EEOC will release it and non-confidential docs to the employee upon request, which is now pretty much 100% of the time. And OSHA automatically provides the response unless it's inadvisable. So think through talking about this issue with outside counsel to determine what documents best should be attached as exhibits so that you're not inadvertently disclosing confidential or other proprietary information about the company. There are several remedies that both OSHA and EEOC will look to enforce, including reinstatement, payment of back wages. You could have punitive damages. You could have compensatory emotional distress, attorney's fees. So these could be pretty significant. So it's important that you've got the right steps in place to make sure that we don't get to this position, and that you're doing the right training to your managers and supervisors to avoid action and avoiding whistleblower retaliation. And I'll turn it over to Amanda for the last few slides.
Okay, now we've talked all about whistleblowers and how the process works and potential remedies, talking about avoiding the situation. So we're not dealing with those. The first thing is training. Train. Letting management know that these are certain activities are prohibited, what sorts of activities are prohibited. Management training, actions that are likely considered adverse. Perception of retaliation and proximity of timing of filing of an employee complaint and without any justification the next day somebody's overtime is substantially reduced without any sort of workplace performance issues. Effectively communicating a legitimate but adverse employee action, and we'll talk a little bit about that on the next slide. In documentation, so training and then documentation to back up decisions that were made, and referring to policies that were in place, and especially if terminating an employee based on a not following a safety and health procedure that ended up in an OSHA inspection, making sure that there's documentation to show that the adverse action was taken pursuant to the policy. Other employees have encountered the same sort of adverse action because they broke the rules. Detailed decision-making process. Basically, the more documentation you have backing up the decision was a legitimate one, it's better your chances are you're not going to be facing a charge with regards to a whistleblower claim. And also, too, investigating complaints of discrimination, retaliation, and documents. It's better for you to hear about the occupational safety and health hazard or complaint before it is notified to OSHA. A lot of people have a system where individuals can put anonymous complaints in the system and they can be reviewed. Keeping notes of work that's done to look at those anonymous plates, talking to employees, keeping records of those employee interviews, and reasons for determination if an action was taken or it was not taken, and providing documentation for that. So those are all important processes in helping to avoid a whistleblower complaint. And that concludes our presentation for today. I hope that you've enjoyed it and learned something applicable to your workplace. And we'll continue to join us on our webinars, as well as check out our blog. We spent a substantial amount of time on all the communication, whether it's the blog or the webinars, and hope that you enjoy them and reference them frequently. That concludes our presentation for today. And see if there's any questions. I know that we're running close on time here on our hour limit.
I saw one, Amanda, that came in. Let me talk about this, about informing supervisors about claims to avoid retaliation. Yeah, the point there was you want to avoid, if a charge comes in, you want to make sure management knows that a charge has already been filed in order to prevent future acts of potential retaliation. The employer knowledge part goes to whether the employer knew about the protected activity originally. And if you can claim that management did not know that the individual engaged in an initial protected activity, that's the defense for the adverse action. Informing a supervisor after the charge has been filed of retaliation would not come into play with respect to that defense of the employer knowledge. Any other questions? Well, this is being recorded, as we said earlier, so feel free to circulate the recording to others if they were unable to join, and the slides. And we hope everyone enjoyed it and got some good tips. And if you have any other questions going forward, don't hesitate to reach out to one of us on the panel today. Thank you.